Hello, and welcome. I'm Torres-Spelliscy, and this is 5 Minutes with the Professor. In this week's podcast, we're going to focus on one aspect of the study, and that is the concept of going public. Now, there are a number of reasons that a company may decide to go public, but the main reason is the access to capital. The sale of securities offers a relatively quick way to raise significant amounts of capital, particularly when traditional lending streams have dried up or have simply become too pricey. But participation in the securities market is not without its risks, both from a market perspective as well as from a legal perspective. In this short podcast, we will talk about the steps necessary and the information that needs to be provided to the public in order to issue your first IPO. Let's start with a bit of a history lesson. For most of the early American centuries, securities represented a wholly unregulated market. It was a bit like the Wild West in terms of financial stability. As I've said in the past, unregulated markets may be profitable, but they are highly unstable. It's simply because there are few protections against fraud and abuse. The result? 1929 stock market crash, the Great Depression. As markets were decimated, the US government under Franklin Roosevelt realized that there was a need to draft new regulations, ensuring that the information being provided to investors was complete and accurate. The government recognized that regulations bring stability by standardizing expectations with respect to certain key issues. Here's a short clip of President Roosevelt discussing the Securities Act in one of his fireside chats.
The second step we have taken in the restoration of normal business enterprise has been to clean up thoroughly unwholesome conditions in the field of investment. In this we have had assistance from many bankers and businessmen, most of whom recognize the past evils in the banking system, evils in the sale of securities, evils in the deliberate encouragement of stock gambling, evils in the sale of unsound mortgages, evils in many other ways in which the public lost literally billions of dollars. They saw that without changes in the policies and methods of investment, there could be no recovery of public confidence in the security of savings. The country now enjoys the safety of bank savings under the new banking laws, the careful checking of new securities under the Securities Act, and the curtailment of rank stock speculation through the Securities Exchange Act. I sincerely hope that as a result, people will be discouraged in unhappy efforts to get rich quick by speculating in securities. For the average person almost always loses. Only a very small minority of the people of this country believe in gambling as a substitute for the old philosophy of Benjamin Franklin that the way to wealth is through work.
As President Roosevelt indicated, the new regulatory era would begin with the passages of the Securities Act of 1933 and the Securities Exchange Act of 1934. The acts were designed to require disclosure and prevent fraud. Over the years, additional regulatory structures have been adopted, including the 2002 Sarbanes-Oxley Act, known as SOX, and the 2010 Dodd-Frank Wall Street Reform and Consumer Protection. Now, as I mentioned, our focus this week will be on the issuance of an initial public offering, known as an IPO. That's the first time a company decides to go public. Now, IPOs are regulated through the 1933 Act. The 34 Act deals with the subsequent sales of securities and the operation of public companies. Here we're going to focus on the 33 Act. That act specifically requires that if securities are offered to the public, they must be registered with the SEC via a registration statement and prospectus. The act mandates that certain information must be disclosed in these documents. Why? The reason is simple. Without strict regulation, there's a massive disparity of information between the average investor and the company. Without the right to receive accurate and truthful information, The average investor arguably enters a transaction blind, no idea of the financial status of the company, the management, the business model. That creates inefficiencies and asymmetries that these laws sought to correct. So let's walk through the process that you have to go through when you want to issue your IPO. First, you need to get your company ready. You need to build a management team with experience. You need to develop internal controls that will comply with public company reporting requirements. This includes appointing independent board members and establishing an audit committee that is compliant with the Sarbanes-Oxley Act. How many independent board directors you need? That depends on which exchange you are likely to register on. But many exchanges require it to be a majority. For example, the New York Stock Exchange and NASDAQ both require the majority of the board be independent. You also need to review your company policies to make sure that your corporate governance principles are in compliance with minimum requirements of the exchange you intend to be listed on and in compliance with the new laws and regulations. In particular, you need to ensure that your financial statements have been audited by a reputable firm in compliance with the PCAOB standards, that stands for Public Company Accounting Oversight Board, and that the auditors are going to issue a clean audit opinion. That's critical to generating interest. Now, as you prepare to file, you'll need to compile a prospectus and a registration statement known as Form S-1. A registration statement describes the securities, the business, the management of the business, pending litigations, government regulations that apply to the registrant, executive compensation, among a myriad of other things. It is filed with the SEC and must become effective before any sales take place. And Part 1 of the registration statement is the information that eventually forms the prospectus, which is a written disclosure that is intended to be used as a primary selling document. Part 2 of the registration statement contains additional information that the company doesn't have to deliver to investors, although it is available for the public to read via the SEC website. Now, this is not an easy process. You're going to need to engage underwriters or bankers, lawyers, accountants, printers to help with this enormous task. It is critical that you conduct sufficient due diligence to ensure that the statements in your filings are accurate to the best of your knowledge. This can be an expensive and time-consuming process and is often where new companies make mistakes. You've got to make sure the information is accurate. During the process, the underwriters are likely to, example, ask for a comfort letter from the accountant. That's where the accountants certify certain financial information about the company. Importantly, accountants may not provide comfort letters relating to the company's ongoing solvency. It's critical to provide true and accurate information because false statements or inaccurate statements can lead to both civil and criminal liability for the directors and officers of the company. So take care in preparing your prospectus and your registration statement. Now, all the documents are submitted electronically to the SEC's EDGAR website. The SEC reviews the documents and responds with a letter of comment, where they raise issues and questions that must be resolved. There are usually multiple rounds of back and forth during this period. And while the SEC is reviewing the documents, the company starts what's called a roadshow. And this is where management travels around the country to present the prospectus to analysts, fund managers, potential investors. The idea is to gauge potential interest in the IPO and to use the process to set a final price. During this period, though, the company must be very careful about what is being said publicly. It's known as the quiet period. The reason is that the registration statement and the prospectus are the public statements of the company. Any other statements might be confusing or misleading to investors. Once the prospectus is out there, the company can do little to offer additional explanations or try to pump up the value of the company before the securities start to be sold. The prospectus is the company statement. The registration statement is. It must be the first and last word. So when all the regulator concerns are satisfied and any amended registration statements have been filed, the SEC declares the registration effective, and it is only then that you may start to sell your securities to the public. As you'll read in the text, the life of a public company can be burdensome. Not only do you lose control as an owner, but you also incur significant costs due to keeping up with annual and quarterly filing requirements. There are a lot of considerations to going public, benefits and drawbacks. So before a company decides to go down this road, they must make a strategic determination as to what is in the best interest of the company. That's it for this week's 5 Minutes with the Professor. Thanks for tuning in, and I'll see you on the discussion.